All right, so today we're going to talk about extreme risk laws. And here's an overview of what we're going to cover during our time here today. I'm going to give an overview of these laws and explain what they are intended to do. I'm going to give some details of the extreme risk protection order process and sort of how that legal process works. We'll talk through some special considerations for crisis responders and thinking about whether this is a tool that can help in your work, in your community. And if we've got some time, I'll go through some case examples of using this law and kind of some specific examples of how it's been used. So that's our plan for today. So let's get into our overview. So what are extreme risk laws? Extreme risk laws create a civil legal process through which law enforcement officers, family members, and in some states, other designated members of the community can file a petition with a court to temporarily restrict a person's access to firearms if there's evidence that they pose a risk of harm to themselves or to others if they continue to have such access. These laws are known by a number of different names. So if you've heard of red flag laws, that's this kind of law. They're known in some states as extreme risk protection order laws, or ERPO. I will probably use the acronym ERPO during this presentation. They're also known as gun violence restraining orders, lethal violence protective orders. If you're familiar with any of these terms, that is the kind of law that we're talking about today. And again, it's a law that is a civil process that temporarily restricts a person's access to firearms. When a person's in crisis and they are considering self-harm or harm to others, they often exhibit clear warning signs. Extreme risk laws are intended to provide a mechanism to act, to intervene when these warning signs are present, rather than having to wait to respond after a tragedy occurs. Extreme risk laws all include due process protections. They all require a judicial finding of imminent risk of harm before they're issued. So this is something that's really important to emphasize here. This is a judicial process. There's going to be a judicial finding before an order is issued. And ERPO will require a person to relinquish any guns that are already in their possession, and it will also prevent them from being able to purchase guns while that order is in effect. I really want to emphasize one point here, which is that an extreme risk protection order does only one thing. It only addresses a person's ability to access firearms. So it does not provide any other relief. It does not provide a connection to treatment. It does not include any other kinds of provisions that are typical in other kinds of restraining orders. So for example, it does not include a stay away provision that might be in a domestic violence restraining order. It cannot address issues related to custody or anything like that. All an ERPO does is address a person's access to firearms. And so this is one piece of an intervention plan in certain cases where that gun access is one of the most acute problems in a particular scenario. So ERPOs are a life-saving tool that are designed to address high-risk behavior. It may be an appropriate intervention, again, when you have threats of self-harm, if there are threats of harm to others, including domestic or family violence, and when there are threats of mass harm, including school shootings. Extreme risk protection orders are temporary. And again, it's a civil legal process. So it's distinct from criminal processes, from arrests and prosecutions. It's distinct from mental health related commitments and any other type of law enforcement intervention. And you can use an ERPO alongside some of these other interventions in cases where that's appropriate. Another big thing to highlight at the beginning is an extreme risk protection order does not require a mental or behavioral health diagnosis, and such a diagnosis would not be sufficient for a court to issue an order. The court is going to make a finding of dangerousness based on behavior. And again, this is not going to necessarily be related to any kind of diagnosis. In some states, the court may consider evidence of mental or behavioral health treatment, history of treatment, diagnosis. But again, it's not required and it's not going to be sufficient in order for an ERPO to be issued. ERPOs are really based on behavior, observable behavior. And again, this is going to distinguish an ERPO from other kinds of interventions like involuntary commitments for evaluation or treatment or assisted outpatient treatment. Extreme risk protection order laws are a crucial part of suicide prevention. What we know is that suicide attempts with a firearm are far more likely to be fatal. And we know that when people survive a suicide attempt, they very often do not go on to die by suicide. And so reducing access to firearms is a very important part of suicide prevention, again, which is how we think of extreme risk protection order laws. And I like to put extreme risk protection order laws in a broader context of other options to temporarily limit gun access for a person in crisis. ERPO is just one option. There are other options as well that might be more appropriate depending on a person's situation, their willingness to voluntarily address their access to firearms. And so we talk a lot about secure storage in the home. If you're a gun owner, storing your firearms securely, locked, unloaded separately from ammunition, to make sure that other members of your household are not able to access your firearms. We also talk about, we call it give the keys, which is a gun owner who's in crisis can securely store their firearm in a safe or in another locked device and give the keys or the code to that device to a friend or family member, just creating another step in the process of them being able to access their firearms, giving a little more time and space. We talk about out-of-home storage, and so there are times where it might be appropriate to take firearms out of the home and store them elsewhere with a family member or with a gun dealer during a crisis period, and that's another option for limiting firearm access during periods of crisis. And then also on that continuum is an extreme risk protection order if it becomes necessary to seek a court order in order to restrict access to firearms. So 22 states and Washington, D.C. have enacted extreme risk protection order laws. Maine is the most recent state that adopted this law and did so this past November as part of a ballot initiative. And so we now have these laws in place across the country in almost half of the states. So are these laws effective? These laws are relatively new. Most of them have been enacted only since 2018. And so we're still learning about the impact of these laws and their effectiveness at reducing gun violence. But there is a growing body of research that is finding that these laws can be effective at preventing suicide in particular when they are implemented effectively. And so there's a couple of studies that I've listed here. There's a study from Connecticut showing that the extreme risk protection order law prevented one suicide for every 10 to 20 orders that were issued. There is a study out of California looking at the use of extreme risk protection orders for individuals who were threatening mass violence, finding that individuals who had an order issued against them did not later go on to commit a homicide or to die by suicide, suggesting that that intervention was effective. So we know that these laws can have an impact and can be a really important tool to help support crisis intervention efforts in a community. So I'm going to now turn to the process itself for obtaining an extreme risk protection order. And I want to emphasize that the details of the process are going to differ by state. So it's really important if you're interested in these laws to look at the law in your particular state to understand the specifics of the process there. But there are some things that we can talk about as a general matter when it comes to extreme risk protection order laws. The first issue is who can file a petition, who can start this process in a civil court. In every state that has one of these laws, law enforcement are able to file an extreme risk protection order petition with the court. Again, it's a civil process, but law enforcement officers are by and large the biggest group of people who file petitions across every state that has this law. In most of the states, family members and household members are also able to file a petition for an extreme risk protection order. This is really important because there are going to be situations where the family does not want to involve law enforcement in the situation that's happening within their family. And so in the states that have this option, a family member can go directly to court on their own and file a petition without having to involve law enforcement at the beginning of that process. And there are a few states that have other categories of individuals who are able to directly file petitions, including medical providers who have worked with the individual, educators, and a couple of states have coworkers are able to go file these petitions. There are, generally speaking, two types of extreme risk orders that are available as part of these laws. The first is a temporary or an emergency order. These are orders that are able to be issued very quickly when there is an imminent risk of harm. Generally, law enforcement will seek these orders. They can go to court without first providing notice to the individual, and a court will evaluate the evidence, will look for evidence of an imminent risk of harm, and a judge can then determine whether or not it's appropriate to issue a temporary or an emergency order. These orders generally last for a short period of time, generally not more than 2 weeks, but provide a way to intervene very quickly when there is an urgent situation involving a firearm. And then in order for a longer order to be issued, the court is going to have to order calendar a full hearing that needs to be scheduled, and the individual will need to receive notice of that so they can appear in court on their own behalf. The second type of order is a final order, and this is the order that would be issued after the opportunity for that full court hearing where both sides can appear, people can have an attorney present if they want to, and they can offer evidence on both sides of the petition. After that kind of hearing, the court can issue a longer term order that reduces a person's access to firearms for while that order is in effect. Generally speaking, the final orders are going to last for up to 1 year, and then they can be extended or renewed if there is evidence that the risk is ongoing. So again, the specifics vary by state, but generally speaking, in order to obtain an extreme risk protection order, a petition will need to include the specific factual circumstances that demonstrate that the individual poses a risk of harm to themselves or to others if they continue to have access to firearms. The courts are very clear that they are looking for specific behavior. So general allegations of dangerousness are generally not going to be sufficient in order for a court to issue one of these orders. The courts are also going to ask if there's information about any firearms that the individual already possesses. This is really important for officer safety when they are serving these kinds of orders. But it's important to know that it is not required for a person to already possess guns in order to get an extreme risk protection order. These orders also prevent the individual from being able to purchase a firearm. And so if you don't have information about guns that are already in that person's possession, but you have reason to believe they intend to go purchase a gun, that will be enough for a court to be able to issue an order. Most of the ERPO statutes include factors that the court can consider in determining whether or not to grant a petition for an extreme risk protection order. The factors are slightly different from state to state, but generally things that the court is going to look for and is going to consider are things like recent acts or credible threats of violence against self or others. And those threats don't necessarily have to involve a firearm. If there's any history of domestic violence or any history of violating previous protective orders, that's going to be relevant information. Information about ownership of or intent to procure a firearm or recent acquisition of firearms or ammunition. history of use or threatened use of unlawful physical force, criminal history for certain violent crimes, evidence of abuse of alcohol or controlled substances is going to be a relevant factor. And courts will often ask and will take into consideration whether that individual is required to possess a firearm or carry a firearm as part of their employment. Courts are going to be very careful about issuing an order that is going to impact somebody's employment. And so they're going to want to know if that is part of that person's condition of their employment. So what happens after the court issues an ERPO or an extreme risk protection order? The judge will explain the terms of the order to the individual, specifically that they are not allowed to possess or to purchase firearms while that order is in effect. The order will be provided to the firearm background check system to make sure that that person cannot purchase firearms during the period that the order is in effect. The individual will be required to turn in any guns in their possession immediately. And so when law enforcement serves these orders, they are going to be asking for firearm relinquishment at that moment of service. Some state extreme risk protection order laws allow a person to turn in their firearms to a licensed gun dealer instead of law enforcement for safekeeping during the period of the order. So it's good to know in your state whether they have that option or whether they need to be turned into law enforcement. The judge will also explain that violating the order can result in criminal consequences. Again, while an extreme risk protection order is a civil order, a violation of the order can convert to criminal charges. The individual will usually have at least one opportunity to request a hearing to have the order vacated before it expires. And so if a person enters treatment, kind of is taking steps to address the underlying causes of the crisis, they can return to court a few months later and provide that evidence and request that the order be vacated before that 1-year period. When the order expires, law enforcement is required to return any firearms that were relinquished, and the order will be expunged from the background check system, so that person will regain their ability to purchase firearms again after that order has been, after the order expires. So we're going to talk now a little bit about just some things for crisis responders to be aware of or to think about when it comes to extreme risk protection orders. As I said at the top, these orders can be an important additional tool for crisis responders to address the immediate risks posed by access to firearms in order to give more time to address the underlying causes of whatever the crisis might be. So again, if you're in a state that has one of these laws, it's worth thinking about how an extreme risk protection order may be an appropriate tool, an appropriate intervention option in some of the cases that you're working on and some of the situations you're responding to. On co-responder teams, law enforcement officers can file ERPO petitions directly themselves. If you're a behavioral health worker on a crisis response team, you might be able to make referrals to law enforcement or work with your law enforcement partners on whether an ERPO petition is appropriate. Or it might make sense to talk to that individual's support system about whether or not they may want to pursue an ERPO, or talk to the individual themselves. There are some people who appreciate the order as a way of really putting a pause on the crisis and their access to firearms. And so that's another option. I'm putting up here the QR code to access the HHS guidance on HIPAA as it relates to extreme risk protection order cases. This is a question I know people always have. There are exceptions to the HIPAA privacy rule to allow healthcare providers to disclose protected health information in the context of an ERPO proceeding. So if you're curious about that and you want to get more information about that, I have that, that information linked here. I'll also say that many ERPO state statutes include provisions related to the disclosure of protected information. And many of the state statutes also have provisions limiting the liability for providers who choose to file an IRPA petition or engage in IRPA proceedings. So I know there are a lot of concerns and questions about liability, and a lot of the state laws do address that in order to provide protections for individuals who participate in IRPA proceedings. So I'm going to go through some case examples just to give you a little bit of a more concrete sense of how these laws have been used in different scenarios in different jurisdictions around the country. At the top here, we have a case from Colorado Springs where a social worker contacted law enforcement after a woman who was on a 72-hour hold made comments showing admiration towards previous mass shooters and disclosed that she owned a couple of firearms. And so the police department there filed an IRPA petition, which was granted. This case, I think, is a good example for crisis responders because it shows how an extremist protection order can maybe be used in conjunction with a 72-hour hold, thinking about how do you support somebody and how do you help ensure somebody's safety when they are being discharged. This is a good example of how an extremist protection order can be part of that discharge plan in thinking about how do we help ensure somebody's safety when they're going back home. We have another case out of Colorado where an IRPA was granted against a man in his 60s. He would repeatedly call police to his home, claiming to have been shot, that there were hitmen in his bedroom. He would dress in law enforcement gear. He was harassing his neighbors. But importantly, part of this case was he was bragging about shooting somebody and he was sending threatening messages to his ex-wife. And so an extremist protection order was issued, and law enforcement removed 59 guns and more than 50,000 rounds of ammunition from his possession. A case out of New York, a sheriff's office filed for an extremist protection order after an individual sent a video to her sister threatening self-harm. Following the 911 call, the individual was taken to the hospital for an evaluation, and the extremist protection order was issued, leading to the removal of a firearm that she was unlawfully in possession of in her home. And so again, this is an example of using an extremist protection order on top of a mental health intervention to kind of extend that safety for when the person was returning home. A case out of Washington State, we had an emergency extremist protection order issued after a man who was experiencing paranoia disappeared from a family reunion. In this case, the man's family participated in the hearing and testified in support of a final one-year IRPA being issued. And the individual ended up surrendering a number of firearms that he had in his possession during the period that this order was in effect. I've got a couple more. A case out of Minnesota, the sheriff's office sought an IRPA against a university student who posted pictures to social media of himself with multiple firearms. And there was evidence that the student was experiencing mental illness, suicidal ideation, and had an avid interest in firearms and in previous shootings. So this was a case where the order was granted and law enforcement removed the students' firearms that they had in their possession. And then a case out of Colorado Springs, there was a therapist who contacted the police department after a patient demonstrated some paranoia, said he was convinced a particular couple was responsible for his friend's death and wanted to kill them. The man told the therapist that he owned a sniper rifle and would shoot them from across the street. And so the police department filed a petition for an extremist protection order, which was granted by the court. So those are just a couple of examples of the kinds of cases and situations where these orders have been sought and obtained. If you're thinking about, how do you incorporate an extreme risk protection order into your team's work? I have a couple of just suggestions here of how to get started. I think reviewing your department's SOPs to see if there's a policy regarding ERPO, and if not, talking to department leadership about how can you put one into place. Familiarizing yourself with the forms. These ERPO process, most courts have template forms and template orders that they use in these cases, and include instructions. And so just getting yourself familiar with what those forms look like is a really good way to familiarize yourself with the process in your jurisdiction. Also talking to and finding a point of contact in the local court who's familiar with the process, who can answer questions and kind of help facilitate that process can be helpful. And then talking to your team about having a training. There are a number of national organizations that offer free training on ERPO, and you can reach out, and I'm happy to help connect you with those training resources as well. And with that, I have my contact information here, and I'm happy to take questions. And if there are follow-ups after the fact, please reach out, and I'm very happy to help support this work in your team.